Washington. The case that could transform privacy law in the digital era began with the armed robbery of a Radio Shack store in Detroit, a couple of weeks before Christmas in 2010. In the next 3 months, 8 more stores in Michigan and Ohio were robbed at gunpoint. The robbers took bags filled with smartphones. Their own phones would help send them to prison. On Wednesday, the Supreme Court will consider whether prosecutors violated the Fourth Amendment, which bars unreasonable searches, by collecting vast amounts of data from cell phone companies showing the movements of the man they say organized most of the robberies. Experts in privacy law said the case, Carpenter v. United States, No. 16-402, was a potential blockbuster. Carpenter could be the most important electronic privacy case of the 21st century, said Jeffrey Rosen, the president of the National Constitution Center, a nonprofit group devoted to educating the public about the Constitution. In a pair of recent decisions, the Supreme Court expressed discomfort with allowing unlimited government access to digital data. It limited the ability of the police to use GPS devices to track suspects' movements, and it required a warrant to search cell phones. Technology companies including Apple, Facebook, and Google have filed a brief urging the Supreme Court to continue to bring Fourth Amendment law into the modern era. No constitutional doctrine should presume, the brief said, that consumers assume the risk of warrantless government surveillance simply by using technologies that are beneficial and increasingly integrated into modern life. The court's decision, expected by June, will apply the Fourth Amendment, drafted in the 18th century, to a world in which people's movements are continuously recorded by devices in their cars, pockets, and purses, by toll plazas, and by transit systems. The court's reasoning may also apply to email and text messages, internet searches, and bank and credit card records. The case is hugely important in that it defines the constitutional role in a really wide range of cases, said Orrin Kerr, a law professor who will soon join the faculty at the University of Southern California. The case concerns Timothy Ivory Carpenter, who witnesses said had planned the robberies, supplied guns, and served as lookout, typically waiting in a stolen car across the street. At his signal, the robbers entered the store, brandished their guns, herded customers and employees to the back, and ordered the employees to fill the robbers' bags with new smartphones, a court decision said, summarizing the evidence against him. In addition to presenting testimony, prosecutors relied on months of records obtained from cell phone companies to prove their case. The records showed that Mr. Carpenter's phone had been nearby when several of the robberies happened. He was convicted and sentenced to 116 years in prison. Mr. Carpenter's lawyers said cell phone companies had turned over 127 days of records that placed his phone at 12,898 locations, based on information from cell phone towers. Prosecutors could tell whether he had slept at home on given nights and whether he attended his usual church on Sunday mornings.